Okay.
Okay. I think this is better. Hello everyone. And those online confirm that you can hear me.
I can hear.
We can hear.
Yes, we can hear you.
Awesome. We're just going to start and make progress. So welcome everyone to today's event. It's Data Science Meets Music Law exhibition. And we have my wonderful students in the Masters in Intellectual Property Law program here at the University of Pretoria. Just a bit of background. A bit of background. So we started this this project that led us to today with thinking about how can we use data science or computational methods to address some issues in law. World Intellectual Property Day is really it's an annual event, and it's this year the focus is on music. And so we started to look at copyright law and the way that it affects or addresses things that happen in the music industry. And so we started to look at the copyright reform process in South Africa and asking ourselves, what are the key music law issues that come up or that came up in that space? But apart from looking at just the copyright law reform in South Africa, we're also looking at the Performance Protection Amendment Bill as well, because there was also that reform process happening alongside the copyright reform process as well. And we decided to look at, okay, what issues came up that affects music artists, music producers, music lawyers as well, and people that work in that space. And then from there, we came up with a set of taxonomy, right? And we're looking at issues that we can identify from the submissions that we are made to Parliament. And based on that, we now transfer that data, that legal data now to our counterparts in the MIT Data Science program as the Department of Computer Science, they are too. So they are currently modeling now and coming up with that data visualization, which we will see subsequently later on in the year. But for us in the law faculty, we now took that a step further to now say, okay, let's take those issues to stakeholders in the music industry and start asking questions and interviewing them and trying to find out how those issues affect them, how do they understand these issues and all that. And that led us to today, where we now have research reports from all of our students, and then we also have presentations. When I decided that this was okay, this is the presentation, this will be the visual communication element, and you had a choice between, okay, you do a PowerPoint presentation, or would you do an infographic, for example? And I kind of suspected that as lawyers, everybody might probably gravitate towards PowerPoint presentation because that's the part of this system. But I was hoping that there would be someone who would say, let's try, let me just do a infographic. But alas, there was no one. So everyone has PowerPoint presentations, which they are going to be sharing today. So my name is Victoria. I'm an associate professor of law in this faculty of law, and I have 3 judges that will be assessing the presentations today. The judges have also looked at your research reports, looked at your PowerPoint presentations, looked at your context in the document where you explain your choices and all that. And so they have idea about how we have approached this task. One of the judges is here, is me, who is here. Let me see, a significant, highly respected, highly regarded attorney who is an IP attorney. Has done a lot of work in the intellectual property space, especially trademarks. We're going to meet her again in the 2nd semester because she usually takes some of our trademark law topics. But she's done also work with Southern Africa Music Rights Organization, SAMIO, in different capacities. And so that's very much in the room in terms of judging. We also have one of my colleagues who is Dr. Potso, who is also joining us online. She's also a music artist herself, so we have that context, like something that affects her directly, not just as someone that is a lawyer, but someone that is a music artist and grapples with these issues. And then we also have Dr. Ifanyo, who is an IP lawyer, an IP expert in one of the leading IP law firms in Nigeria. He also got his LLM in IP law at UCC, and is also very much on. So you can see that we have judges who are very who have expertise to assess your work and to be able to give you feedback to also improve your learning in the space. So welcome everyone, and both those online and those here in person. The way that the presentations will go is, I initially wanted us to have like different groups. So I assigned, there are 15 presentations, and we have 5 presentations that each judge will respond to and give feedback and ask questions that then answer or not, but we should answer. And then we go to the next person. We're going to be very strict with time and move forward. So once you stand here and start presenting, I will start the timer. Once you hear the timer, just please go and sit down so that we can, just stop talking so that the judge in question can ask you a question. And please, no long-winded answer. We want to go straight to the point. And it's okay to say, I don't know or I haven't thought about this. And just don't put us to the excruciating pain of having to worry about coming up with the answer if you don't have an answer. So we'll run like that. And then we will have the audience vote. Depending on how we see things, we can have the votes at the end of the entire presentation so that we can run along quickly. And it's just a popular choice vote for the audience in terms of your oral presentation, how you present and what we get from your presentation. So it's straightforward, it's easy. In terms of the order that we will run in the presentation, we will start with Dao and then we will go like that. If you want to go next after Dao, or you have absolutely need to go next, then give their name to tap into us so that we can let them and then just know that you're next. Otherwise, we just go after Muga, we go to Cindy, we go to Senzi, and we go like that. So you just know when you're to present. Are we good? Yeah? And if you feel that you're not ready, then you must you must work it out with whoever is sitting next to you so that we just have that flow going on. And then when you stand here, I need to actually know that order just so that I can put up the presentation from here. And then when you finish, you need to say your name and all that so that the judge will know that they are going to be likely to ask you questions or anything like that. Are there questions? Or so we're going to move like that and start with.
Good day, everyone. Someone left the whole Bible Korea, so can please ask you disco / DJ with Apple.
Greetings, ladies and gentlemen, and to the judges. My presentation is really to explore the aspect of the proposal in relation to the Copyright Amendment Bill. We will call it the CAP for now. The copyright as it stands, it kind of gave us a clear understanding as to what would constitute fair use and fair dealings, and same is found in the Copyright Act section 12 to 19. But the proposed amendments seek to change that with additions that are put in relation to the fair deal and the fair use. And in relation to that, one engaged on a research in relation to the proposals done by various groups concerned about this amendment and the insertion of these sections, which will have a serious detriment to their industry and the economy there too. In my presentation, we wish to explore that, and I have structured it to just quickly deal with the issue of what is fair use and dealing as per the Act, and also to look at from a layperson's viewpoint, what does that mean, and the impact in the work. And in addition to that, I have to explore a bit of the regulation and or authority that seems to be guiding us at this point in time. So we can then proceed in the first slide. The first slide really is just a summary of what I spoke about in relation to what is listed in the copyrights. Just a moment. What is listed in the copyrights, particularly on those sections, you would see that in summary, I give and or state what was fair dealings and or fair use under those sections. I do not wish to bore you with that. We don't have enough time. We can move to the second slide. So the CAP seek to really put more amendments to it. You would see that there's a proposal where we put section 12A, B, C, and D. In relation to that, there are more rights that are protected than under that as an exception to say that we will be using your work and we will adapt it. For an example, one of the interesting points were to cover for those who are disabled, if you have to adapt your work, in particular the aspect of braille. I think one of the interesting conversations I had with an artist called Itzkoff, I asked him a question in relation to if you have produced your work in a form of music or a song, and you have not converted or adapted it into a video or cinematograph work, and somebody explores that in relation to, you know, if your music is inspirational, so they want to demonstrate that to the greater community, particularly those who are disabled, deaf, and or blind, particularly the people who are deaf. What would your issue be? And you would see that in his answer, he was saying that organizations that stand for those people would have to consider compensation, even if it's once-off, so that he can continue doing his work. That is dealt with when we continue. If we can continue to the next slide. The next slide, it was just a summary of what has been proposed. And what is interesting is the test at which the CAP seeks to show that in terms of whatever that the exploration of your work, provided it's not for economic benefit, they are asking that they should be entitled to use that. When you have time, we should go to section 12AB of that proposal. For the sake of time, we won't be exploring that. If we can move to the next slide. In summary, you would have seen that about 10 submissions that I was able to extract dealing with the aspect of fair use. We have different organizations, the joint submission by the Independent Producers Organization, the Nation of South Africa, Independent Black Film Makers Collective. They've raised really concerns in relation to the fair use, and they say it should be rejected as something that is fraud and unintended. I guess time has cut.
Thank you, Mr. Mnau. I'm the judge for your presentation.
Thank you, Judge.
That was clear, thank you. I'm interested to know why your report was in this particular format that you chose in terms of just having it as the interview. and the answers to the interview questions?
I think as a lawyer, sometimes when we have things in black and white, we tend to get too formalistic, but because of the industry, and when I looked at how some of the presentations were done in Parliament, they were catchy. You know, one could go through those slides or presentation without being, you know, feeling obligated. You know, it was more of it is the whole space as to it made it neat and more attractive, if I can put it that way. So I think the reason why I chose that is that it's not really boring. You know, there's some color there, and one can follow up in terms of the presentation.
And I'd like you, because you mentioned the fair use and the fair dealing, I'd like you to give me your view exactly about where you think it should go. Take a side.
To be honest, in my presentation, I did say that there will be a serious impact given the industry and the economy that South Africa is trying to build for these artists. One of the points that I had discovered is that some of these artists come from disadvantaged backgrounds. They don't have enough network and or resources to start up, and so they rely on companies that will be publishing this work for them. So to be quite frank, the aspect of the fair use, and there will be some serious impact into the economy, which will frustrate these artists and or those in relation to the money.
Thank you.
Thank you.
Yeah.
Good evening, everyone, ladies and gentlemen. Thank you for having me today. My presentation is in regards to the impact of the fair use exception on copyright protection. Prior to compiling a report in this regard, we were asked to make a taxonomy. To this end, the taxonomy we have created relates to the key music law aspects regarding the development of copyright. To this end, we simplified legal concepts to clarify that what the implications of the proposed copyright amendment bill would have in the Copyright Act. And additionally, we focused on other key terms prevalent in the Copyright Act itself, such as author, adaptation, and infringement. The most important being as to what is classified as an author. An author in the Copyright Act in relation to music is the person who first makes or creates the work. And a copyright in musical work shall not be infringed if the author demonstrated sufficient skill and effort in making the work to give it a new and original character. Extrapolating this into the research report, we had been given various submissions from Parliament regarding their stance on the Copyright Amendment Bill, and we also interviewed other key stakeholders. To this end, I interviewed Mr. Gustav Snyman, who is a legal practitioner in copyright law. In the report itself, we explored how copyright influences the protection of original works, and we examined the potential that the fair use provision will have in the Copyright Amendment Bill in practice. Next slide, please. So the first key stakeholder to take a look at is the performer itself and what their rights are. So performers not only contribute their creative creations, but also their finances in the distribution of their musical works. These rights and the distinctive interpretations they bring to stage are legally protected. Without such legal protection, there would be no incentives for authors to continue making original and creative works. And these protections, known as copyright, is regulated in the Copyright Act 98 and 1978. Next slide, please. So the two key exceptions that are outlined in the Copyright Act itself relates to Section 12 and Section 40. Section 12 provides that the use of a musical work does not constitute copyright infringement if it is used for private study, research, personal use, criticism, or review. Personal use makes sense because you cannot be held liable for copyright infringement each time you purchase a CD or even play button. However, Section 14 on the other hand provides that copyright shall not be infringed if a person in South Africa makes a sound recording or a copy of the work or an adaptation thereof. Section 1 of the Copyright Act also defines adaptation in relation to musical work as an arrangement or transcription of a work to give it a new and original creative input, provided that copies or similar adaptations were previously made in or exported into South Africa for a retail sale with the license of the copyright owner. So these exceptions itself are rather confined and not open to misuse. However, next slide please. Then comes in the proposed fair use exception in Section 12A of the Copyright Amendment Bill. So the Copyright Amendment Bill was, in other words, introduced to amend the Copyright Act by providing better descriptions of certain phrases or expanding their part. Furthermore, the bill introduced a fair use exception, further expanding the scope of the statutory exceptions. Whether use of a word is exempt from copyright infringement depends on several factors, including but not limited to the nature of the work, the extent of the part used in relation to the whole work, the purpose and character of the use, whether it serves a different purpose from the original work, and the potential impact the substitute work itself could have on a commercial market. Then the Copyright Amendment Bill goes on to give certain fair use exceptions, such as tributes, homages, and pastiches. So pastiches are somewhat concerning. Next slide, please. As a past, if you look at the first image, you'd see that a pastiche is a musical piece that mimics the style of the earlier work. And if you look at the next image, it may also combine elements of various existing works. Next slide, please. So I have discussed the concerns regarding the broad scope of pastiches with Mr. Schneiman. We might also agree that a pastiche is just too vague and open-ended and subject to misuse, as it would allow persons to copy a work and make it well, you need to speak faster than that.
Hi, Christian. I was wondering, in the course of your research, did you consider the opinions of the trade unions of teachers in South Africa, as well as even perhaps the users of musical works?
The trade union of teachers themselves, I did look at submissions such as from PASA, the Publishers Association, where also confirmed that the inclusion of the fair use provision in the Copyright Amendment Bill is subject to misuse, and it would not incentivize authors to create new and original works, and their suggestion was that it should rather be removed from the Copyright Amendment Bill.
That's the opinion of the publishers, yes?
Yes, but otherwise from the teachers themselves, that involves more literary works, and I'm of the opinion that copyright is much more protected when it comes to a form that is written down, such as a book or a literary work, and less automatically as with the music industry, which is already saturated in copyright infringements of performers or who use, for example, pastiches, and that includes similar works For example, if you take a boy band and you listen to one song, you listen to all of the songs. So for example, the protection itself should already be much more limited instead of being expanded.
I see. Okay.
Then I'm mixing up. Yes. What's your name? In my No, you said it to me. I just need to bring it up. So when you guys start.
Good morning, everyone. Thank you for having me. I am Nandi Shabangu, and my presentation today is going to focus on moral rights and adaptation in South Africa. So, brief introduction. So, this year's World IP Day is focused on, the music industry and how it interacts with intellectual property. And I chose to focus specifically on moral rights and adaptation because these are the issues that affect South African artists like the most. And yes, so can we go ahead? So moral rights is basically a very important part of copyright law, and it manifests itself in two imperatives. The one is that every composer or every creator has the right to be attributed or to be recognized as the creator of the work that they have created. And then the second right that they have is basically that they can defend their works from reputational damage, right? So I'm going to focus specifically on attribution. So yeah, it guarantees that an artist is recognized as the creator of their work. And this has economical consequences, and it has consequences on just their career prospects, right? So when an artist is, they put time into a work and then they're stripped of the right to be recognized as the owner, so they can lose a lot of money and they can lose just the ability of their career to move forward and people to So this is a very prominent issue in institutional collaborations and features. So in the instance where multiple people will work on one thing, and then one person now takes the credit for everything, and the other person is just left on the outskirts, and they have to fight to be recognized as a creator or as a co-creator of that work, and it also goes into. Can you please So they're deprived of royalties and they're deprived of recognition. And in as much as intellectual property is very important in these situations, the other important aspect of the law is contract law. So in South Africa, copyright law, it happens automatically, right? And so there's no system of registration. So there's, in the absence of reducing everything down to paper, there's no, like sometimes there's no evidence that, okay, these people came together and produced this thing. So that's why it's really important to put everything down on paper, because intellectual property is important, but because there's no formal registration, there's just a gap. So move on to the next slide. So I spoke to a lawyer and she pointed me towards the direction of Jerusalem, a very popular song in South Africa and I think internationally. So what had happened there is there were 3 people who wrote the song, and it was Master KG and Mumbai and DJ Shamsa. But when the song was now released into the world, DJ Shamsa, he was basically cut out of the deal, so he wasn't recognized for his contribution, which was a very big contribution. So he is subsequently denied royalties and financial stability that comes with, royalties and the career growth there. Next slide. And the other example of what happens when people are denied their royalties is the case of Solomon Tunda. So he composed, he composed.
Time. Yes. Yeah. Thank you. I'm your judge. Yes. I'm interested to know why you chose to go the moral rights route.
Specifically because the music industry is basically, it can get quite exploitative in the sense that you create a work and then you put your blood, sweat, and tears into it, and in the end, you basically on the bench while people are gaining money, people are gaining recognition for your work. So it's very, very important to have your name down on these works that you created. It's very, very important because intellectual property, it protects your creative expression. And the moral right is that one thing that ensures that you are recognized for your creative expression. So I think that's why I chose it, because of how important I feel to be in not just the South African context, but in the music industry across the world.
So do you think it's automatically there's a connection between attribution, you call it, and the financial reward?
Not necessarily. Yes and no.
Yeah.
Because you can be the author of something, but someone else can be the owner, right? So in the instance where you are both the author and the owner, there's financial implications there. But if you are just the author and not the owner, it doesn't.
Yeah. So what would you advise your client if you were representing a musician?
Okay.
Yeah.
Wouldn't it depend on whether they are part of like a record label?
Would.
So it depends on what's in the contract itself. If the contract says, okay, as a record label, we own what you produce, then what can I say? Okay. But if the record label doesn't own the work, then I would tell this person, hey, this is what your contract says. So when you do that stuff, make sure you get your money. Like, make sure you get your money. And
so you agree that there are layers of,
yes,
from one aspect of time. Thank you. I enjoyed your presentation and your help.
morning, everyone. My name is Mohammed, and today I'll be presenting on copyright reform in South Africa, bridging law and music in the music industry. This presentation forms part of a broader inquiry into how legal reform, specifically the Copyright Amendment Bill, are experienced on the ground by creators, and how far the law truly goes in supporting innovation, creativity, and justice in the music industry. Next slide, please. This presentation draws from multiple sources: legal text, academic commentary, stakeholder submissions to Parliament, and an interview I conducted with a locally based artist. What emerged was a complex picture, one where the law's intentions do not always align with practice, and where artists continue to face significant obstacles in asserting and enforcing their rights. My goal today is to critically explore these tensions and highlight where reform efforts should be concentrated. Next slide, please. Slide 3. To begin, let's consider the legal landscape. South Africa's primary statute, the Copyright Act, is widely regarded as being outdated, particularly in light of digital content creation and online distribution, also known as the Fourth Industrial Revolution. The Copyright Amendment Bill, alongside the Performance Protection Act, seeks to modernize this framework. Key developments include the Constitutional Court live essay case, which confirmed that the current system infringes on the rights of visually impaired persons. The Marrakesh Treaty also plays a role in reimagining access to knowledge as a human right. Scholars such as Beta and Kube and Samtani have pointed out both the promise and pitfalls of the proposed reforms, falling proportion in implementation. Next slide, please. In analyzing stakeholder submissions to Parliament, I developed a taxonomy of 5 key legal themes. Firstly, ownership and authorship, where many creators struggle to determine and document co-authorship. Second, licensing and royalties, a frequent point of frustration for musicians due to unclear systems and delayed payments. Third, performers' rights, a neighboring right which has received strong support from organizations such as SAGA and the PMA, who push for remuneration rights and contractual protections. Fourth, digital exploitation, especially relevant for online platforms raised by the IPO. Lastly, access to justice, a theme echoed in both the Kirsten Crowd submission as well as my interview, where the difficulties of asserting one's rights without aid is reinforced. Next slide, please. The artist's insights were incredibly telling. He discussed how collaborations are often informal, no contracts, no split sheets, just an eagerness to release the music. On royalties, he's registered with Samro and Professor, but describes the process as opaque and frustrating. Streaming often offers little income, and he feels ill-equipped to challenge infringements. Although he welcomes the idea of reform, he is skeptical. Next slide, please. These insights reflect broader tensions. Performers and creators seek control and fair income. Producers and industry bodies warn against rigid legislation that could stifle investment. And access advocates such as Professor Kirsten Krauss support reforms that allow educational reform and digital access. The government is caught balancing constitutional rights, trade obligations, and industrial policy. These submissions, which I was tasked with reviewing, clearly map these ideological divides. Next slide, please. Despite the ambitious changes in the amendment law, the practical situation remains precarious. The artist's insights show that rights, while now stronger on paper, are not readily enforced or understood. Collecting societies often lack transparency. Legal services are too expensive. The informal nature of collaboration often adds further complexity. So while reform is welcome, implementation remains the key challenge. Next slide, please. One area where the copyright law and social justice intersect is accessibility. The blind essay case compelled government to act on its Marrakesh Treaty obligations. Sections 19B and 19C of the bill address the right to create accessible format for persons with disabilities. Krauss and others support this as essential for educational access and education. In this slide, copyright is no longer about just protecting creators. It's about enabling access to culture and knowledge for all. Next slide, please. This research has shown me that copyright cannot operate in a vacuum. Parliamentary submissions consistently point to the need for enforceable, comprehensible, and accessible rights. The artist's voice illustrates the disconnect between reform and reality. And while my taxonomy helped systemize these issues, It showed that technical classifications must be coupled with grounded understanding. Reform must be more than simply legislative. There needs to be investment in education, in legal support, and in cultural infrastructure. Final slide, please. In conclusion, for copyright reform to truly succeed in South Africa, we must think beyond legislative drafting. Reform must include. Thank you very much.
Hi, that was a good presentation. Just a quick question. So when it comes to contracts between collaborators, right? Do you think there's always fair bargaining power between the collaborators, especially where, say, for example, a celebrity musician decides to feature an upcoming artist that is desperate to, make it big out there? So do you think there's always that fair bargaining power? And if not, what can be done to address that?
Well, as I stated in my presentation, the artist such as the one which I interviewed, he is a locally based artist who recently came into the limelight with the release of his new album. And one of the points I touched on was when creating music in such a setting, usually he does enlist the services of some people who might contribute in significant ways and smaller ways, but often the question of compensation doesn't really come into the question until the track really gains traction and really starts accumulating streams. So the bargaining power is really uneven in that sense. But I guess in response to that, the final label in my taxonomy, access to justice, is most pertinent with regards to your question. So I believe education for all those involved in the music industry, whether it be performers, up-and-coming artists, producers, it's important that all of these stakeholders are informed on the nature of these terms, of these relationships, where they should be compensated, how to approach procuring that compensation, regulating their relationships between artists and in these collaborations through contracts, etc., registering with the relevant associations such as SABRO and CAPES. Yes.
All right, thank you.
Amongst the presentations that I have here. What's your name? Sonny. I'll find yours. Sorry. I see it in my view, but I need to move it from my view. Who is ready to present? Some people want to present.
I'll be discussing the Copyright Amendment Bill and the issues and legal concepts that are contained therein. Next slide, please. These include fair use, personal use, freedom of panorama, royalties and collective management organization, reversion rights, moral rights, arbitrary deprivation of property, accessibility to copyright work for persons with disabilities, and compliance with international treaties. These legal concepts were found in the submissions that from stakeholders that I reviewed as well as from an interview I did with Isaac van der Merwe, pianist for the Cape Town Philharmonic Orchestra. Next slide, please. Fair use was introduced to Section 12A and has created a lot of concern among stakeholders. On the screen, you will see a comparison between fair use and fair dealing. Fair use allows the use of copyright work without the permission of the stakeholders in an open-ended number of circumstances, whereas in fair dealing, it has a closed list in circumstances where you can use copyrighted work. With fair use, it also requires a case-by-case analysis to determine if the fair use is permissible. Whereas with fair dealing, it is clearly defined in law when fair use, use is allowed. Next slide, please. Personal use is another exception that allows individuals to copy entire works for non-commercial use. The Copyright Amendment Bill expands on the personal use that is already in the Copyright Act in 3 ways. Namely, it allows copies from different devices at different times, copies for non-commercial use, and transient copies for technological compatibility. This personal use has raised concerns regarding the income of musicians. Freedom of panorama, another exception, has been introduced to the Copyright Amendment Bill, and this allows the creating and sharing of images and buildings and sculptures and other works of art that are permanently located in public spaces without the fear of copyright infringement. Stakeholders such as Wikimedia South Africa have argued that this allows for celebrating South Africa's rich culture. There is an image there of the Nelson Mandela Memorial statue that is located outside of the Union buildings. However, the statue has been censored out, and without freedom of panorama, sharing this image would result in copyright infringement. Next slide, please. Royalties and collective management organizations often go hand in hand. And through the Copyright Amendment Bill, musicians are now entitled to equitable remuneration or a fair share of royalties received from their commercial work. This must be agreed on between the parties, and where there is still a dispute, it must be referred to the reinvigorated Copyright Tribunal. Collective management organizations that are tasked with collecting these royalties have raised concern over the lack of clarity of what is equitable remuneration, and has argued that this will result in many disputes. These collective management organizations would previously lack oversight, which led to low collections, high management fees, and poor accountability. The Copyright Amendment Bill aims to correct this by placing oversight and introducing regulations. Next slide, please. Reversion rights has also been introduced into the Copyright Amendment Bill, which reverts rights back to the original owner after a 25-year period for literary and musical works. Critics have, however, argued that the 25-year period is too long, as a work has most value in the first 10 years. Next slide, please. Moral rights, which was previously always included, was only for authors where they could claim authorship and therefore object to distortion or misuse of their work. However, through the Performance Protection Bill, it now includes singers and musicians. This is important in an AI era, as now musicians can object to AI-altered work. Next slide, please. We cannot look at the Copyright Amendment Bill without discussing the legal and constitutional issues there. Many stakeholders have argued that the new exceptions violate Section 25 of the Constitution, in that it is depriving copyright owners of property without sufficient justification. This too was raised by the President, and that is the reason why the Copyright Amendment Bill was referred to the Constitutional Court, where it will be heard on the 21st and 22nd of May this year. Another constitutional issue was raised by Blind SA when they argued that the Copyright Act lacks provisions for people with visual disabilities. The Constitutional Court agreed that the Copyright Act in this aspect was unconstitutional.
Thank you. Sorry. Before, so after Sam, the people that can present any of the following: Cindy, Unisani, Elios, Faithful, Sepo, sorry, I'm not reading your name, or collect, because those ones are for the online documents that are online, and I prefer to be able to finish fast. So who wants to go after saving, right?
Thanks, Ismail. I enjoyed your report and your presentation. I thought it was quite comprehensive. So of these issues that you've raised quite a few, and how there's been the impact of the amendment. Which one for you stands out as the most important?
I would say fair use stands out as one of the most important ones. It's because it has such a knock-on effect not only to musicians, but to lots of people in the creative industry. And also, there's no case law to determine what is fair use. And as I mentioned in my presentation, with fair use, it is determined on a case-by-case basis. So people who often need to defend their work and take it to court, which is one thing I discovered through my interview, is that they don't have the funds to engage in lengthy court arguments to get a decision to establish case law. And then another one from speaking with the musician that I did is that the lack of AR provisions in the bill is a concern. Because as we've seen that we are moving into an AR era where things can be done by AR, and they find that we must protect the creative industry against AR being able to do things cheaper and then they're not having work.
So would you advocate for fair use versus fair use?
I would advocate that we must stay on the fair dealing. What we have it's clearly defined in law, it protects the industry, and it does provide cases, instances where people can use copyright works without the permission. So it's not like it leaves people without options.
And now the fact that you brought in AI, and that means easily,
Yes.
Surely fair use is now, right in that direction. Where AI is not something that is used, so clearly that might not exactly deal with that issue.
I feel like with AR, we need to have strict laws in place to clearly define when something can and can't be used. And I feel that fair use is so open-ended that it allows AR to kind of run away with it. Whereas with fair dealing, I think it provides a more structured and limited use, which will limit the use of AR to sort of technical implementations. Thank you.
Morning, everyone. My slide, my name is Salim Shatani, and I'll be focusing on the protection of artists' rights against exploitation. The reason I chose to focus here is because of what artists or musicians experience regarding in relation to their royalties. And also the main reason I chose this is the IP researcher that influenced my presentation. My topic was the IP researcher, a specialist by the name of Untitled Chapter. He really helped me with focusing on or having to focus on this topic. Why copyright matters? There has been a significant growth in the past 2 decades with young and diverse talent. And also, the reason I chose to focus here is because of when we were doing our taxonomy, we were focusing on either a professional or a lay person, or having to define legal issues in a lay person. So that's why I chose to focus on lay person, because I realized that most of musicians, they do not know how to read their contract, or they just sign without having to have a clear idea with regard to what legal terms mean to on their contract. So why copyright methods? Music contributes to development of tourism and culture. It also influenced artists, but however, artists face challenges in protecting their rights. Copyright ensures fairness compensation on original work. Copyright also gives creative exclusive control over usage and usage, distribution, and performance. Why copyright? What copyright protects? In Section 2 of the Copyright Act, it protects the literary work, musical work, artistic work, sound recording, films, and broadcast. And we should take note that also it protects the computer programs, and also that a single song may include multiple protected elements, which can be lyrics, sound, and music. There is a misconception with regards to the word property, but on Section 25 of the Constitution includes the word property as include the word, it protects the word property, and this was analyzed in the case of Gallo Africa versus Sting Music, where it confirmed that property as a property, where it confirmed property as a movable assets or property. As rights of artists, so when I was doing my presentation, or when I was doing my research, I had to put down the rights of artists. IP rights are constitutional protected. You can see that from the copyright and the amendment. A composer's creation is legally equivalent to a landowner's property, which is what the case of Gala speaks about. Reinforcements, legal and economic respect. So these were the questions that I came up with. Sorry, Prof, for saying next slide, but yeah, I'm on slide 6. Yes, these were the questions that I came up with, or that I outlined when I was doing my research. I'm not going to go through them, but I'll just read them, but I'm not going to. What career challenges do musicians face? What financial constraints do they experience? How do educational gaps, discrimination, and gender disparity affect them? What is the role of rights organizations? How do royalty distribute work? How effective is the current copyright or copyright amendment? I'm on slide 7, Prof. So, role of collecting societies. So also, when I was doing my interview, we spoke a lot about collecting societies, which can be your sample and etc. That they do protect what they protect, which is licensed music use to radio station, to TV station, streaming platform, and etc. And also the royalty collection, which can be collecting of fees from music users based on how.
Hi, Cindy.
Hello.
So I like your the design of your presentation. It's really nice. I'm curious though as to your. Can you hear me?
Yes, I hear you.
Okay. All right. I'm curious though as to your questions, the interview questions you explored. don't you think that they come off, how relevant are they to the topic? And do you think that they come off as leading? For instance, I know one of your question was around what career challenges do musicians face? I'm struggling trying to align it with the the discourse that you are supposed to make or explore. And then what financial constraints do they experience? How do these questions fall into the issue at hand? I cannot hear you if you're speaking.
Okay. Can you hear me now?
Yes, I can hear you now.
Thank you. Maybe there might be a typo, but the reason behind my questions, I wanted to focus more on that. I know that most of young artists, they take music as their career. Because also there is like a music institutions where they just teach you everything that has to do with music. And the financial part was when I realized that most musicians, they suffer with having to be able to pay for your recordings, having to be able to pay for your studio recordings, your music videos. So that's when I realized that I need to focus on these topics because when I was having an interview with an IP researcher, we get to explore that most of these young artists, they get the recording, the collective societies, which are the recording labels, they take them and they give them money, whereas they receive the money before they could even do the work. That's why we experience or we see a lot of young artists, they are not doing well financially because they focus more on making money or being popular, not looking at the long term.
Okay, thank you.
Molani is not here. No. There's another circle, not you. Where is this second? It's not here. It's not here. Okay.
Good afternoon, good morning everyone. My name is Faith Chamba and I'm going to be making a presentation on the copyright system in South Africa, the shortcomings and the changes that need to be made. But I'm going to start from just making it clear to everyone that the Constitution is the supreme law of the land, and in it has Section 16, which provides for freedom of expression, and Section 9, which is the Equality Clause. And I want to make it clear that the Copyright Act that we're currently using is from 1978, and we're currently in 2025, so we are no longer in apartheid era and all that, so we are in a different space now. So I'm going to look at the Copyright Act, which is the legislation that is responsible for all the rights that can be exercised by a copyright owner. And there's a few things that quite stand out for me, and those are listed on the slide. Next slide, please. Recently, submissions were made by different organizations, but what stood out for me is that it's large organizations that make submissions and not ground level or grassroots artists, because I'm of the opinion that their voice also needs to be there. But there was little presentation on their part. Next slide, please. Some of the concerns that were raised in the submissions was the difficulty in accessing copyright material, therefore slowing down the creation of new works. There was the unconstitutionality of the Copyright Act because it discriminates against physically impaired individuals, as converting copyright protected work into braille or any other forms is considered as copyright infringement. Next slide, please. I had an opportunity to do an interview with a person who is a musical artist. So I opted to go for the ones that are still starting up. What stood out for me is the lack of knowledge in those people. I mean, they're just trying to put bread and butter on their table, and everything else that comes with the sections and the ads and the writing, they don't do. So this makes them vulnerable, and if a promoter or a well-up artist brings a substantial amount, they will take it and give away all their rights just like that for that, because of that amount that is offered to them. I interviewed the first two people, artists. They didn't know what the Copyright Act is about. Then the third person that I got to interview had an idea, but still, it proved to me that on ground level, there is no knowledge. Next slide, please. Those amendments are meant to make the Copyright Act constitutional and make a version that is compatible with the fourth industrial revolution and ensure that the creators' works are protected and they get fair compensation. It is important to ensure that loopholes are closed to allow for platforms that host copyright protected material without sorry. So I'll just go to the next slide, which is the afterthoughts. And I'm gonna stay here for a while. As much as it is important to amend the Copyright Act for reasons earlier stated, if the people on the ground do not know about it, it defeats the point. The people that are affected most, being the artists, need to have a say, need to have a platform to be heard. The voices that we hear right now in the submissions are mostly of middlemen, if I can say. That's 10. That is. Okay.
Hi, Faith.
Hello, Prof.
So nice presentation slide. There are three things I wanted to discuss with you. The first is this. Now, generally, I read your report and the slide, and from what I can see, you're heavily tilted towards the lack of awareness of the Copyright Act. And you are using that as the basis to argue and give reasons for the deficiencies of the Copyright Act. I think there are two separate issues. For instance, if you're saying that somebody is not aware of the act, it's a different ballgame. It doesn't mean that the act itself is deficient, right? It's a question of maybe some administrative system that needs to be put in place to make people aware. But if you're talking about the deficiency in the act itself, then you're talking about perhaps that the law is unfair, is unjust, and the rest of that. So I was finding it difficult to see how that relates to the issue of your report and your research. That's the first thing. The second is, I'm not so sure you brought out the parliamentary submissions and addressed them in the course of your presentation. Do you want to speak to this too? And again, yes, the final thing, the third thing is, and this is more of like, I just want to get your thoughts on it. Did you study the concept of fair use? Because in the course of this, and you mentioned some exceptions, but did you study the concept of fair use as it is in America, in the United States of America, and what South Africa proposed amendment is trying to achieve? And where does the balance, where does the balance tilt?
Okay. So, like I said in the presentation, as much as we want to amend the bill, or we want to, it all goes down to people knowing what we are amending. People that are affected by the Copyright Act that we are trying to amend must know what it contains. So I struggle to separate one from the other, because amendment and awareness, I feel like they have to go together, because even if we amend and the people are not aware, it kind of defeats the point, I can say. Thank you.
Thank you very much.
Morning, ladies and gentlemen. Standing before you is Stefan Dubai, and I'll be presenting on the managing the music scene in South Africa, the effects of the Copyright Amendment Bill. Introduction. The Copyright Amendment Bill, also known as CAP, has generated a lot of discussions. These amendments have significant legal and economic impact for the creative industry. And also during this presentation, we also discuss on fair use and concerns around it, and copyright enforcement, and also compliance with international treaties, which are very important. Compliance with international treaties. Concerns about South Africa compliance with international treaties are voiced in the CAP, and also possible violation of contracts, including the copyright treaty of the World International Property Organization, also known as WIPO. As you know that upholding international standards in copyright law is very important for promoting cross-border cooperation. Now to discuss on fair use. The fair use laws in the Copyright Amendment Bill aims to increase restrictions on the reproductions of copyrighted works, such as remixing or sampling of music. It's also made to encourage creativity, innovation, and also invention while expanding to access of knowledge. But there are problems around fair use, such as unrestricted list of exceptions, which may cause confusions about what exactly qualifies as fair use. And also the danger of expensive legal actions for creators requesting payment for copyright usage. Effects of fair use on creative community. The fair use principle may come with a lot of advantages, but also put South African creators at risk. Innovation and creativity may be disguised by application of uncertainty. To safeguard the rights of content creators, the definition of fair use must be fairly explained. Safe harbor clauses. Safe harbor clauses are absent from the current Copyright Act. if you look at section 75 and 77 of the Electronic Communication and Transaction Act, these two sections, they give you safeguards for streaming platforms. But still, these platforms are not responsible for user posted material until request takedown request has been disregarded. Enforcement of copyright versus access. The amendments in the COV are meant to strike balance between freedom of access and enforcement. It is important to protect the creators' rights to promote innovation and guarantee public access to information. This practical implementation of this balance will be shaped by these ongoing discussions. In conclusion, South Africa's creative industry faces both opportunities and challenges as a result of this Copyright Amendment 3. This ongoing debate are important on dealing with these complex consequences of care. The future of copyright in South Africa will depend on promoting legal clarity and also global compliance and also greater protection. As we are celebrating our World IP Day, with the theme in IP and music, I thought I'll include this last slide, which was taken from Bible, which says, from the rhythms that invite us to dance to the lyrics that echoes our emotions, music enriches every aspect of our lives. Music is a universal form of creative expression. Intellectual property rights play a pivotal role in supporting vibrant and diverse music landscape. Thank you.
Thank you for that. It was an interesting presentation. And I'm glad that you brought in World IP Day as well. Can you mention any other forms of IP that musicians and artists in this area, even performance, what they could use? Any other IP?
So can you repeat that, sir?
So in your presentation, you mentioned World IP Day. So we're talking intellectual property on the broader sense, not only copyright. Can you tell me if there are any other forms of intellectual property that you would perhaps advise your clients to approach so they can get forms of IP protection, not only copyright protection?
Or also trademarks. The trademark their names is also
their own names, their personal names.
No, their stage name.
Okay.
Like AKA and
yes. Anything else?
If I remember from IP, umbrella IP, there's also design of the sleeve, the music, the things. In back in the days, they were using CDs. I don't know now. The sleeve, the art of the singer, that can be on the side.
So, in terms of the current copyright law, if you had a client who was an artist in South Africa that uploaded something onto YouTube, how would you say he should protect what he has done in terms of the current copyright act? So, say for example, somebody else uses what he has uploaded. What do you think are his remedies in terms of the current act?
You mean let's say you mean if an artist upload the music on YouTube,
his own music,
okay,
but somebody else uses it or uses a sample of it?
No, you know that in South Africa, copyright is automatic. Once the artist releases the music, then protection is automatic. So the artist can also engage on infringement, but the music can be taken down from the platform.
Okay, thank you.
Good morning, everyone. My name is Tulisani Mayani. I'll be focusing on the stakeholders' views on the copyright amendment bill and the commerce protection amendment bill. Now, just to emphasize the submissions that they submitted regarding these two bills, is that SAT2, for example, is the teachers' union. So they mostly concerned about education that they are providing. Probably I can say when they are teaching music, probably in primary school or in high school. And then PSA is Performance Association South Africa. And then the other one is PMA, which is Personal Managers Association for Netflix. Netflix mostly as audiovisual plus multi-choice. Please move to the next slide. The next one. Now, on such two position regarding those two bills is that they are supporting the act, the Amendment Act. Now, I just want to put it to everyone that there are those which are supporting the amendment of these bills, and there are those ones which are against the bills. So I will be focusing on two of them. I took two submissions from them and the two others which are against, but I'll start with these ones which are supporting the bill. They now start to represent teachers that called regions in South Africa, as I've mentioned, that they are those ones who are mostly in education. They say they support care for improved access to education and information. They further argue that the current law is outdated and excludes disabilities and those with disabilities, that is and hinders digital learning. And they also said the pandemic highlighted copyright limitations during remote learning. So now they had a concern on their submissions to say that when they were conducting their classes, they could not share because of those strict copyright laws, and they couldn't probably do well teaching those ones who were far from them. Please move to the next slide. Now, SAT2 legal and international context. They are informed by international treaties. Where is that? Like WIPO, is WIPO there was written like WIPO and Marrakesh. It's just that it's faded there. Yeah. So they are actually informed, or they've studied the international treaties like WIPO and Marrakesh, and then they further say that Marrakesh supports access for the visually impaired. So now they're saying that since at the beginning, those ones who are with disabilities are excluded, but the Marrakesh Treaty made them to make submissions that also supports those ones who are visually impaired. Now, they claim that CAP does not conflict with international treaties, as they have went through it and they've used proper legal giants to support their submission. This is the next slide. Now, this is PMA, Performance Managers Association. Performance Protection Association. Please, I don't know, so they are advocating for performance rights. These are the submissions of performance personal yes, you have me there. And then it seeks to six ethical practices in entertainment. Now, they want to get away with people who are in the entertainment industry from being robbed and all those things. And then the second one is it empowers performance economically. So now it advocates performance. This association advocates for performance so that they can economically gain from their copyright rights. Yes. So it aligns with the Benjamin Treaty and also the Benjamin Treaty advocates for 4 rights, which is economic rights and economic rights, right of distribution.
Hi, Dumisani.
Hi.
Thank you for that presentation. I thought you were caught up with time. First, I think I'm happy with your presentation and the manner you went about your research. I think you are the only person in my group that really tried to balance the two views to the issues around, including the parliamentary issues around the discourse. So that's a good thing. Thank you for that. However, two things in your I'm trying to look how you related this to those parliamentary submissions. That's one. And two, were you able to, what's your view, your conclusion really? It's kind of it's left open. Are you able to take perhaps a stance, or at least a recommendation if you're not taking a stance, to say, oh, in view of these two opposite view, this could be a better way to go?
Yes, I'm able to take a view. It's just that I was still on those ones who are supporting the bill, and I have not got to those ones who are opposing the bill, like Netflix and Minority Choice. But I'm in my stand. I'm supporting the group of SAT2 and the other few who agree.